Asikubingelele sikwamukele kwezesizulu mbukeli siyathemba ukuthi benempela sonto enhle. Mbukeli ngeviki ledlule sibonile umprofeti ovelele uShepherd Bushiri evele enkantolo yena nonkosikazi wakhe nabanye asolwa nabo ngamacala enkohlakalo elinganiselwa ku100 million wamarandi. Icala liyelahlehliselwa unamhlanje. Mbukeli ngikhuluma nawe nje usevelile enkantolo njengoba icala liqhubeka. NjengeGalaxy Universal Network siyakwethulela lona bukhoma. Hlala unethezeke ubone ukuqhubeka kwaleli cala.
When we extrapolated the facts that was set out in the affidavit of the state is the following. The state wishes this court to draw an inference from past conduct that the applicant, and more specific applicant number 1, has a tendency to interfere or intimidate witnesses and or deal in inverted commas with cases. Yet each and every one of those cases that the state has referred to in their affidavit, all of those things, as your worship correctly pointed out to the state, happened prior to the arrest of the accused in February 2019. So if it was the state's, or if it is the investigating team, and with the greatest of respect, whether there's a change in prosecution makes no difference. The very same investigating team that's on this case was the investigating team at that stage. If they seriously thought that the applicants has such tendencies as they set out in their affidavit, they should never have agreed to grant them bail. But they did. Your Worship, what is in... I'm going to, let me just continue and deal with some of the issues vis-a-vis that has already been stated with reference to the state's heads of argument. Your Worship, I have in my heads of argument, just by way of introduction, explain to the court the background of the case. And Your Worship should never lose sight, as my learned friend is, of the fact that the applicants were arrested in February of 2019. They were arrested on serious charges. The state elected to, when they indicted them to stand trial in the High Court, add even more serious charges. And what is important under those circumstances, Your Worship, is the fact that despite the allegations made now, the state, as I say, elected not to oppose bail. They in fact granted bail, as I've already submitted to the Honourable Court, in an amount of bail, and to that extent, Your Worship, since this is an inquisitorial process, I have managed to secure for this Honourable Court's benefit the charge sheet as well as the relevant court order so that the court can see exactly what the court order stated, the conditions of bail, and that bail was granted. Now, Your Worship...
Right, before you proceed, have you had sight of this copy of the charge sheet?
Yeah, I've got one for my learned friend too, Your Worship. Your Worship would see it is duly stamped by the Regional Court Magistrate, and the very last page, marked 3, is in fact the court order. We have, for sake of convenience, just so that Your Worship knows it's not from another case, also added the J15 so that it's evidently clear what the position is.
All right. State, I want to accept it as evidence. Do you have any objection?
I don't have, Your Worship.
Right. A copy of the charge sheet, which bears case number 111 of 24/2019, is accepted as evidence, marked Exhibit Z.
May it please the court, Your Worship.
Yes, you may carry
Your
on.
Worship, under heading B, background and basis for arrest, the state, and it's sort of the rationale for making almost a meal of this point escapes me, makes reference to the arrest of the accused. Now what we have done, Your Worship, page 3 over to page 4, and it ends on page 5, we've dealt with this. Let me just summarize so the court understands again. There was an arrangement for the applicants 1 and 2 to hand themselves over. We also found out later that applicant 3 was sought. We tendered from the word go that we will hand over all 3 the applicants. Was it not for the fact that the investigating team, despite the conversation myself and my attorney had with them, did not keep their word and wait for us to also hand accused number 2 over, applicant number 2 over? All these applicants voluntarily have surrendered themselves. The only thing that's important for this honourable court to know is that there was from the beginning, even on the state's version, when this issue was discussed with Mr. Nkwashu, a tender by both the first and the second applicant to voluntarily surrender themselves. What is further important to note in this respect, Your Worship, is the fact that I would submit it's common cause that all the applicants knew that this case was being investigated for a long period of time. We know that from the case numbers. January of 2019, already a month before the previous arrest of the applicants. March of 2019. Your Worship, I make the further submission here that this actually is a non-starter in the greater scheme of things. What is important in our case, it's almost a trite principle, where the court can manifestly see that applicants does not run away from the fact that there's warrants of arrest or that there's an intention to arrest them, but in fact voluntarily surrenders themselves. That is a positive factor in the interest of justice that the court should take into account in favour of the applicants. Your Worship, the thing that I find quite astonishing though is, and I refer to that in paragraph 6 on page 3 of my head, is the following. It's the state's case that warrants of arrest were obtained based on the fact that, and I've cursively and underlined it in that paragraph, the prospects of a successful prosecution will be in jeopardy should one or more of the suspects evade arrest, places a serious question mark, I submit, on the strength of the state's case. Your Worship, the statements makes no sense to me. But to an extent, it's substantiated by the lack of particularity in the charge sheet. Even when the state had an opportunity to extrapolate on the very cursorily lacking in detailed charges, they failed to do so. Your Worship, what is further important is the issue when one deals with this particular situation is that the state makes no suggestion or no submissions to Your Worship why the background of their arrest and why this statement should have any bearing or should play any role in this court's decision to grant or not grant bail. Worship, we then deal from page 5 with the issue of the charge sheet and the charges, and that is basically dealt with, Your Worship, in paragraph 8 and also referred to in other places by the state in the heads of argument. So I'm not going to repeat what I said to the court about the lack of information and detail in the charges. What is important though, Your Worship, if one has regard to my learned friend's heads of argument, she seems to infer to this honourable court that there's an onus on the applicants to explain to the court what their defense is, and how they, let me leave it there, what their defense is. My learned friend forgets that the applicant has a right to silence, even at this stage. In the absence of particularity in respect of these three charges, how does the state expect the applicants to prefer any defense? We don't know when the offenses was committed. We don't know who the complainants are. We don't know when this was committed. Now the state expects us to prefer a version and challenge the strength of the state's case. What is there to challenge, Your Worship? My learned friend cannot seriously submit to this court that what is set out in the affidavit and what is set out in those three annexes to the J50 constitute a serious and strong case. It does not. And this, of course, Your Worship, we have to take against the background of them having investigated this case on their own version for 1 year and 10 months already. I've made the submission to Your Worship when the state opportunistically tried to get this matter postponed in terms of the provisions of section 50 sub 6, that when you make a decision to arrest people on a warrant of arrest, one would expect you to be ready with a charge sheet that's legible, that's understandable, that contains particularity, and at least, with the greatest of respect to the state, conforms with the provisions set out in the Criminal Procedure Act for what should be contained in a charge. None of that is applicable. Your Worship, I specifically refer the Honourable Court in paragraph 20 on page 6 to State versus the Court. That is an SCA decision that says, when the state has failed to make a case or has relied upon which is lacking in detail or persuasion, that a court hearing a bail application cannot express even a prima facie view as to its strength or weaknesses, the accused must receive the benefit of the doubt. And I can think of no case that's more apt when we deal with the strength of the state's case with reference to the charges and the charge sheet as this particular case. Your Worship, the state then deals with various aspects, which is all set out under the heading the bail application. None of these has a particular heading, but what we've done for the benefit of this Honourable Court, we've tried to compartmentalize, say, Your Worship, and we've done that with reference to section 60 sub 4. So we've dealt, for instance, with the issue of the flight risk, and there specifically, Your Worship would see on page 7, we've dealt with the issue of travel and passports. Now, what we say to Your Worship here, I've dealt with it vis-a-vis the first two applicants and then the third applicant. The most important point that the state tries to make to the Honourable Court here is that the applicant failed to hand over one of his passports. Now, Your Worship knows from your experience, and I have no doubt that my learned friend, who's the current prosecutor, and the investigating team, who's got years of experience, knows if an accused person has not complied with the condition of his bail can there and then be revoked. Yet they didn't do it. That is a factor that this court must take into account in favour of the applicant, of the first applicant. Your Worship was not even taken into confidence by the state by saying, well, we've done research and we know that this particular passport exists. So, with the greatest of respect to Worship, this is plain, good old-fashioned speculation and innuendo and opinion. I made the point, as I've made during the start, in paragraph 9, page 29, the state does not justify why this issue is now relevant and why it wasn't relevant in February of 2019. Regarding the third applicant, and that pertains to the issue of, maybe let me just go back one step. I've also touched on the issue of travels. The state already knew in 2019, February of 2019, beginning of February 2019, that the applicants were frequent travelers, that they fly on chartered jets, that there's certain allegations allegedly pertaining to their conduct at the various airports. Yet again, and I have to emphasize it, that did not come to play and was not significant enough for the state or the investigating team at the time to utilize it as a factor to oppose bail. Why is it now suddenly a factor, and why was it at that stage not a factor? What is important, though, Your Worship, is that, and I want to state that conduct trumps speculation, trumps opinion, trumps allegations. What is the applicant's conduct shown to this honourable court? It showed to the court that they are people that will stand their trial. Having faced increasingly more charges in the other matter, they didn't endeavour to evade that trial. They stood their trial. They adhered to each and every bail condition that the court imposed on them. That might, with respect to worship, trumps any speculations or any opinions that the state might come up with at this stage in this particular bail application. Regarding the third applicant, Your Worship, there's an allegation made that she has 2 passports. Now, Your Worship does numerous bail applications every single day. How does the state know there's more than 1 passport? They've got access to a system whereby if you put the ID number of a person in and you do the word passport, it spits out all the passports that were issued to such a person. Now, I've got no doubt, Your Worship, that when that happened, when they saw that there was 2 passports, they would also have seen that the 1 passport expired. Why do they mislead the court by saying there's 2 passports where they know that one of those passports have expired? It shows plain and unadulterated malice in this matter. Your Worship, we have tendered, and we hereby still do tender, to hand up the passport that the applicant has in her possession. If Your Worship so wishes, we can hand up that passport, but just as proof again of the fact that the passport has expired, we've got a copy for Your Worship of the expired passport, so that Your Worship can see that there can be no suggestion or innuendo as the state tried to do in their affidavit, that the fact that the applicant has 2 passports makes her a flight risk. Your Worship, I then
Before you proceed, Advocate Rosenblatt, do you have any objection that this copy of an expired passport be accepted as evidence?
Bishop, I haven't seen the original. This is not a certified copy. I cannot agree to this.
Where is the original defense?
The court will just bear with me. Your Worship, with the greatest of respect, the investigating officer sitting behind my learned friend for the state, he can go and check it. We say to the court, this is a certified copy of the original, but we will endeavour at the end to hand over the original to the court.
Right, the document will stand until such time when the original has been produced.
Should I also just remind my learned friend for the state that these are informal proceedings. And as such, the state cannot expect of each and every applicant to come to the court with the best evidence, certified as such, etc. Bishop, I then move on to the issue of residence and immovable properties. This is the current passport that is in in play and that we have tended to hand over to the court. Your Worship, then we deal with the issue of the residence and the immovable property. My learned friend has made quite a, or endeavoured, let me rather put it this way, to make a meal of this issue in both the affidavit and has lightly touched on it in their heads of argument. I'm going to summarise the situation plainly for them. The first and second applicant are the owners of a property in midstream. That's undisputed. The third applicant is the owner, together with her husband, of two properties, one in Port Elizabeth and one situated in Cape Town. What is the relevance of ownership of these properties, Your Worship? It constitutes assets. Assets constitute is a factor that the court can take into account why applicants will not flee. It was never suggested or argued or put forward by any of the applicants, Your Worship, that those properties are where they permanently reside. In respect of the first two applicants, our case is patently clear. The first two applicants live at the property in Waterfall Estate. We know that the second applicant was arrested there. And I've referred to the Honourable Court, I'm not going to repeat it. There's some allegation by nobody that he doesn't stay there. In the affidavit, they don't say who said it and under what circumstances was said. I think I have quoted, in fact I did, paragraph 39.1. I've quoted to the court the specific quotation from the said affidavit. Then it goes on, Your Worship. It makes reference to information that was received about the fact that the second applicant was a tenant in another property. We've explained that under oath in our supplementary papers. We said, yes, in our name, there's a property that we lease. But it's for our brother, he stays there. The state didn't take issue with that. The state didn't even endeavour to deal with it in its heads of argument. It's safe to make this bold statement that they've got information in respect of the fact that there's that they previously got that accused number 4 is a tenant, other addresses. Your Worship, what's also important here is that the state tries to suggest to the Honourable Court that the first and the second applicant also leases other properties at different addresses in different names. Your Worship, it's again, I fail to see the relevance of that in the greater scheme of things. They are the directors of many companies. That's never been challenged by the state. It is trite, Your Worship, that when properties are leased by companies, those are done in the name of the directors. So what is so strange about that? Your Worship, I have mentioned in here the fact that these allegations pertaining to the other properties is not substantiated by facts. They don't come to the court and say, look, this is why we make these allegations and attach CIPC documents. Again, just a vague and bold allegation. There's no substance in it whatsoever. They don't even say to the court why they submit. It is a factor that would induce the applicants to flee. Your Worship, with reference to the allegation pertaining to the Sparkling Waters Hotel, Your Worship would recall we've made the submission to the court that is ongoing litigation. I have, for the benefit of this Honourable Court, procured from the relevant attorney that deals with it the notice of motion. And from this notice of motion, the court can clearly see that there's a rescission application that was brought on behalf of SPI, the first and the second applicant in this matter. That proves to the court or that puts pay, let me rather put it like this, to the suggestion or submission by my learned friend that there's this enormous debt currently facing them and that that will induce them to run away. In fact, if the learned court has reference to the date, it's June of 2020, long before the applicants knew about this case. They already started proceedings to set aside that order that was given at the time. Now I will sit down so the court can again deal with it.
Right, Advocate Rosenblatt, any objection that this copy of the notice of motion be accepted as evidence?
Your Worship, I would request that the rest of the case be then placed before court, that I have an opportunity to do so, because I know that this case was heard and it was struck from the roll or the application was denied. I have had information to that. I don't have it with me. I would request that this not be admitted to evidence until the whole picture is before this court.
Your response, defense?
Your Worship, with the greatest of respect, if my learned friend wishes to adduce evidence to the contrary, I don't understand why she didn't, when she in fact got her investigating officer to depose to an affidavit, even produce the evidence at that time. We didn't raise this issue, the state raised the issue. So all we're doing right now, we're rebutting what the state said.
So what they are saying, Advocate, is not the true state of facts. The fact that the matter was removed from the roll.
Worship, with the greatest of respect, I hear what my learned friend is saying, but I'm submitting to this honourable court is, if it's their case, that is what the position was, I would have expected them, when they deposed to this affidavit, and they made references, chapter and verse to this application, as if they had access to the court file. Why did they not also deal with that issue in this application? Where their papers end off, Your Worship, and if you go to that particular, to the paragraphs where they deal with it, on page 25 of their heads, why did they not go further? It's again another example of them not taking this honourable court into its confidence. Why did they not there say? And so, by the way, we know that in June, the applicants brought a rescission application, but that rescission application was struck off the roll. They didn't do that. They've decided in their own wisdom to place facts before the court, which is incomplete. With the greatest of respect, they should now bear the fruit of that, Your Worship.
Right, because this is an inquisitorial procedure, the court needs to be given all the documents in order for the court to reach a just and fair decision. I am going to accept this document and mark it as Exhibit AA.
May it please court, Your Worship. Your Worship, with regard to the third applicant, Your Worship, there's a suggestion made that she's not monitorable at the property in Port Elizabeth and the one in Cape Town, the ones to which the title deed referred. It's never been our case, Your Worship, that we live there. It's our case that we own those properties. What the applicant's case has been, the third applicant, is I stay at this property here in Johannesburg, and when I'm not here, I stay with my husband. Her version in that regard, and so too for the issue of the title deed, Your Worship, has been confirmed under oath by her husband. Your Worship, we did request the Honourable Court to deal with the issue of the mother's statement JM3, and the state sort of put pay to that. What we have done, Your Worship, though, is we have obtained Uber receipts in respect of the third applicant's travel. Your Worship, and from these receipts, it is patently clear the 2nd of October, the 3rd of October, and we've just taken a sample for the court to see, as well as the 4th of October and as late as the 11th of October. It clearly shows the applicant leaving with an Uber from the address that she states is her permanent address where she resides in Johannesburg. And it also shows often her arriving back at the property in the late afternoon. Your Worship, in the absence of having had the opportunity to speak to the mother herself to understand this, we respectfully submit that according to the best evidence rule, this is the best evidence we can at this stage produce to the court. I'm going to beg leave to hand it up to the court, and my submission in that regard is this objectively puts pay to the mother's affidavit where she said she came to visit me on 15 or 16 October and then she left it. This proves beyond a shadow of a doubt that the applicant, when she left Cape Town on the 2nd of October, went on numerous occasions to the house in the afternoons and left that house in the mornings. I beg leave to hand this up to the Honourable Court as the best proof we can pertaining to the issue of her residence at the said property. Your Worship would note, if you have a look at it, the date is reflected in the right-hand corner, and if Your Worship then goes down, there's Uber X at the bottom of each of these receipts, and then it reflects the time when the property leaves, and Your Worship will note OC Elm Avenue, Witkoppen. That is the address where we respectfully submit the applicant resides.
Any objection to this document, Advocate Rosenblatt?
Bishop, the question is, whose Uber receipt is this? I know it's about an address, but I can't see who's the passenger that paid for this, unless the defense can indicate to me, because I can't read it.
I will place it on record, Your Worship. It's the applicant's husband that assisted us yesterday. I can confirm that we have verified this. This is printed directly as a sample from the applicant's husband's phone. I'm not sure if he's in court today. He is there. Your Worship, he can stand up and this can be confirmed with him.
I've had sight of this document, Counsel. It is your client's contention that she resides at this address. These documents I don't deem fit to admit on record. I'll just take your client's word when she says that indeed she resides at that
May it
address.
please the court, Your Worship. All I've intended to show to the court is that what the mother said is objectively refuted by other objective evidence. May it please the court. Your Worship, I would then continue. There's the issue of work and business that the state also tried to make again a meal of. With respect to Your Worship, it's common cause. The state never disputed that the first applicant is the prophet of EGC, that his wife is the prophetess, that they earn the set of money they do, and they've got a huge congregation of following in South Africa. Your Worship, that again is the start and the end of the fact that they are employed and that they have business interests. Now, the state has made a point at some stage about the fact that there's no mention made in the assets of the prophetic channel. Your Worship, it's common cause, and I think somewhere in their own papers they mention the fact that the prophetic channel changed its name. It is now Y Major 1. If the court just if the court bears me, it's in fact attached to our affidavit. It's the top on the asset list. It's specifically reflected there. So it isn't so as the state suggests in their affidavit and in their head that we failed to mention that particular business to the court. We've mentioned it in the current, or having the current name that it has. Your Worship, the state also misleads the court when it comes to the issue of the third applicant's work business issue. Your Worship, she's played open cards with the court as with reference to her current position. None of that was challenged by the state. What they have done is dug out old companies that she was allegedly or is allegedly a director of. CIPC documents are not placed before the court. This is pure speculation. If you want to play open cards with the court and ask the court to deduce something from this fact, I would have expected them to produce evidence to this court and say, look, this CIPC document states this or this one states that. And what we want the court to find in respect of this is X, Y, and Z. They've not done it. So again, I respectfully submit, it's not an issue that this honourable court should take into account. Your Worship, regarding the issue of family and friends, I have originally in my submissions comprehensively dealt with the issue of the relationship with the first two applicants and their child. I've actually gone to the trouble to look up the specific word when you live as a family unit. It means it's a mother and father and children. It can be a mother and father and brothers and sisters. That's all it is. I have dealt with this issue and I've explained to the court what is important. My learned friend incorrectly refers to the two affidavits which we handed up in opposition to their applications for section 50 sub 6. My learned friend seems to forget that at the time we asked for a short adjournment, we came back and we said, what we can do to oppose this application is to hand up draft affidavits that we got that deals with certain of the issues that the state raised in the section 50 sub 6. We subsequently, during the bail application, handed up bail affidavits, which bail affidavits in paragraph 9.2, and I've pointed it out to the Honourable Court in my heads of argument. Both of the affidavits, 9.2, deals comprehensively with the issue of the children. It clearly says they live together with their children in a family setting. The children, since late 2018, has been living full-time in Malawi. The children comes to visit them on a regular basis. That the investigating officer, Colonel Maritza, sitting in court, has assisted with the children travelling back to South Africa. Court must take into account February 2019. They cannot travel anymore. So the only way they can see the children, as opposed to when they were previously free to travel up and down 5-6 times a month, is for the children to come here. It's a common fact known to everybody. More so, Your Worship, the children were here, they're still here according to me. The children were there in the house at the time that the arrest was effected. Your Worship, the suggestion by the state that the applicants are alienating assets is just not substantiated by proper facts. The basis for this is almost a frivolous remark here and a frivolous remark there. Your Worship, it is a fact beyond any reasonable doubt that their businesses are still intact, that they are operating. We have placed in our supplementary affidavit the fact that despite their allegation that the ECD Church has no cash flow, we've placed under oath what the current position is pertaining to the 2 relevant years and the income statements, what is in their account. Bishop, we respectfully submit thus that when the court has regard to the issue of fixed assets, family support, business, a huge congregation of followers, the third applicant's whole family that's here, except of course for her half siblings, which she says she's not seen for many years, which was never disputed. Every single fact or factor that the court can take into account to the benefit of the applicants has been proven by the applicants. Whatever is stated by the state in opposition amounts to speculation and innuendo. They failed to, when they've had the opportunity of a year and a half, of more than a week since this bail application started, they failed got to come to this court and present the court with proper facts to substantiate these allegations. Your Worship, with regard to the issue of the vehicles that were allegedly or illegally exported to Malawi, where is there any proof to the court about this fact? Now, usually we all know, and I would say it's common, it's a common and it's a well-known fact that if you leave this country's borders with a vehicle, you have to have in your property a proof of ownership as well as your insurance documents. Those go through the immigration system, and that is recorded. We also know, Your Worship, that customs and excise are one of the government sectors, they work under SARS, that is extremely efficient and well run. Now, if there were any suggestion at any stage that vehicles were illegally exported, I have no doubt that Customs and Excise would have there and then been on the applicants and or the entities, because it's actually not even their vehicles according to the state, save for one. These vehicles all belong to different entities. They would have gone to the entities and dealt with the issue. Because Customs and Excise, if this happened, would have lost out on enormous amounts of money. And in terms of the provisions of the Customs and Excise Act, they're entitled to make sure that those monies are paid. So I make the point, Your Worship, in paragraph 6, in conclusion, that the allegation that the applicants had limited fixed assets is patently misleading. I'm not going to repeat the asset, Your Worship. It's there. It's common course that they own these assets, and that pertains to both the first, the second, and the third applicant. Your Worship, we've also dealt on page 18 with the financials and other obligations in South Africa. I've stated very clearly that it is clear from what is stated by the first and the second applicant that they feel a huge obligation towards their congregants. That is not being disputed by the state in any form or manner. Similarly, in respect of the third applicant, she stated under oath she's got a financial and an emotional obligation towards her mother and towards her two nieces. That similarly has not been disputed by the state. Your Worship, your court will see that I've already addressed the court on the movable assets in the vehicle. I've set that out for the court in page 19 and in 20. Your Worship, we then briefly deal with the issue of private planes and international hotels. Again, Your Worship, a bold and vague statement is made in this regard. Where's the proof of this? Since when do we refer the Honourable Court to websites and to articles published in newspapers? We've got a whole investigating team, Your Worship, that's working on this case for almost 2 years now. Come up with proof. Don't make such vague and bold allegations. Bishop, let me just go back for 1 second to the vehicles. At no stage is there any suggestion, and the state makes reference to all these vehicles, that any of these vehicles were paid directly by Rising Estate. And that is a very important factor to take into account. We know there's some really unfortunate innuendo pertaining to the proceeds of crime that allegedly landed up in the bank account or in the trust account of my instructing attorney. It's very unfortunate, Your Worship, that the state would go to that extent and make such unfortunate allegations without having proof. Your Worship, the law on proceeds of crime is quite clear. Your Worship knows from your own experience there's something called commixtia. And without this court being afforded the opportunity to see the so-called paper trail of this money. I want to again place on record that the state stooping to this low is an extremely unfortunate. Your Worship, we then lastly, and I think I'm almost at the end of my head speech after this I deal with the allegation, deal with Exhibit N. Now, Your Worship, Exhibit N is this handwritten affidavit that was handed up by the state. The court will just bear with me. By one Constable Mabasu Batadla. Now, the first thing that one notices is that this statement was obviously obtained and commissioned on the 30th of October 2020, when this case was already being dealt with in court. We then read through it, Your Worship, and there's, again, vague and bold allegations made in here. Now, my first question, or the first question that raises one's suspicion here is, why are these cases not with the same investigation team? Why is it being investigated by somebody else? Secondly, Your Worship, with the greatest of respect, I don't have to even argue this to this honourable court. If you read what is stated in here, it is vague, Your Worship. There is no substantiation in it for any of the statements that's made in here. But the answer to this is a very simple one, Your Worship. Even when the state has, even when the police has investigated these cases, it stands them free to go to the prosecutor, obtain a warrant of arrest, and if the prosecutor so sees fit, a warrant of arrest can be issued and they can then appear before a magistrate where these issues can be dealt with. It's not for this court to have vision into the future as to whether there's überhaupt any case to be investigated, whether the accused will überhaupt be linked to these offences, whether the state will überhaupt decide to prosecute these cases. Again, Your Worship, this statement is added purely for malice. The state can deal with these cases if and when the accused are arrested on those. Your Worship, I have then dealt or set out for the court with reference to my various submissions cases, with specific reference to some of the submissions that I've made. I've also, for the benefit of the court, gone and extrapolated from the toy the relevant portions in the toy that deals with these various issues that were raised, and that was just for Your Worship's ease of reference, that you don't have to go through the whole of the toy to find these particular issues. If the court would bear with me, I just want to approach my attorney here.
Yes, sir.
May I approach the applicants just to make sure?
Yes.
I want to end off literally where I started and say to the court, conduct trumps speculation, conduct trumps innuendo, conduct trumps opinion. The conduct of the applicants has shown beyond any reasonable doubt to this court that there are people with integrity and people that will stand their trial at the end of the day. May it please the court.
Thank you.
Oh, Your Worship, sorry, there was just one thing. The state made reference to only two of the family whose details were provided to the state. Your Worship is free, and we submitted more than two, to look through. We've handed up a whole bundle of correspondence. The court can see from there what was handed over. Your Worship, and just on that point, I've quoted to Your Worship the issue of foreigners. The mere fact, even if they had no family here, that is no bar to them being granted bail whatsoever. May I please?
Thank you. Right, I need the whole of tomorrow to prepare my judgment. Can we proceed on Wednesday, the 4th of November with the judgment?
I'm sorry, Your Worship, can I just request an opportunity? The court will remember during the affidavit read into the record, there was reference to, and I read into record, the Department Home Affairs affidavit, of which I only at that point had a copy. I am in possession of the original signed and commissioned affidavit. I just received it this morning via courier. With the court's permission, Your Worship, I beg it to be handed up as an exhibit.
Right, any objection by the defense? Have you seen the original, counsel?
I believe it's for in relation to accused number 1, Your Worship.
Yes. Is it necessary though? Accused number 1 has not brought a formal bail application.
Yes, I believe maybe should be in the proceedings for accused number 1.
Yes, Your Worship. The court will also see reference to the page, last page of the affidavit, where it refers to anybody that gives harbor, etc., to a person of the nature of the accused before court. It was read in. I would submit that it should form part of the record.
It doesn't take these proceedings backwards or forwards. It's relating to accused number 1 who has not yet brought the formal bail application.
As court please, Your Worship.
Advocate Mkhochwane, by the way, it's relating to your client. Any objection that it be handed in as evidence?
No objection, Your Worship.
All right. An affidavit from the Department of Home Affairs accepted as evidence, marked Exhibit BB.
Thank you, Your Worship.
Your Worship, I am very sorry. I promise it's the last time I'll address the court. My attorney just reminded me I've not dealt with the issue, and I'm going to simply say to the court, there's an interdict pertaining to the issue of the first and second applicant's plea of statement. And I invite the court to go and read the order. The order at this stage unequivocally keeps their current position intact. It doesn't say that there's an ongoing investigation of this. So I'm not even going to quote it to the court. I know the court has read the judgment, but look at the order specifically. May it please the court.
Right, can we proceed on Wednesday, the 4th of November?
What time will the judgment be handed down, Your Worship?
The latest is 9:30.
Your Worship, there will be somebody here to note the judgment. Then we put it to the court.
All right.
Your Worship, may I please place on record that on the 4th, I'm busy with the trial in the court 18 at the serious commercial crime court.
One of your
If
colleagues to stand in for you.
If it's possible that we can hear this case just after 10, then I can make arrangements, because my colleagues are busy with the High Court matter.
When you say after 10, it's after 10 before what time? Immediately after 10. Or shall we say 10 o'clock?
10 o'clock, Your Worship.
All right. Is 10 o'clock okay with your legal representatives, counsel? Somebody
Your
who will
Worship,
stand?
I'm sure, as I said, somebody will be here to note the
It's
judgment.
fine. Let's place it at 10 o'clock then. Advocate Mkhochwane, you're also available on the 4th of November?
I confirm, Your Worship.
Thank you. Advocate Matopo?
Your Worship, if I'm not available, my attorney will be present in my place.
Thank you. The accused persons, please rise. Judgment is going to be delivered in this court on the 4th of November 2020, court number 16. That is, if there is no space in court number 16, we'll sit here in court number 6. It is for judgment in a formal bail application in respect of accused number 2, 4, 5, and 6. All of you will be in custody until then. You may stand down.
As the court pleases, Your Worship.
As the court pleases, Your Worship, I assume your worship is going to adjourn.
Most certainly. Court adjourns.
Maar we zitten natuurlijk via de rapporten. Dus dan moet ik vast. Ja, dat zal wel. Ik wil niet zo.